Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Got a couple people sending me a story recently about a drunk driver who was pulled over, charged with drunk driving, and fought it on the grounds that the police officer shouldn't have pulled him over in the first place because he wasn't speeding and the cop thought he was. And a Michigan Court of Appeals has agreed with the alleged drunk driver. The story comes to us from the Detroit Free Press, the paper I delivered as a child. Michigan court rules in favor of drunk driver, says cop had wrong speed limit. Article written by Anna Bauman of the Detroit Free Press. Northbound lanes of Parsonage Road in Saranac, Michigan have a 25 mile per hour speed limit sign, but southbound lanes do not. That's important. So evidence against a drunk driver must be dismissed because he was pulled over unlawfully for speeding in an unmarked stretch of road, according to a Michigan court opinion. The Michigan Court of Appeals delivered the unanimous decision Wednesday regarding an Ionia County traffic stop that they say violated an individual's constitutional protection from unreasonable searches. So Anthony Owen was arrested in 2015 in the village of Saranac. He failed a breathalyzer after being pulled over for speeding. The deputy stopped Owen because he was driving 43 miles per hour in what the officer thought was a 25 mile per hour zone. The officer was wrong. The deputy made an ignorant, unreasonable decision that violated the man's Fourth Amendment right by stopping him in what was actually a 55 mile per hour zone on the hunch that the speed limit was 25, according to the court. So this is a great example of one where they asked the officer, and he apparently said under oath, yeah, well, I had a hunch that the speed limit was 25. A hunch? Can't write tickets based on hunches. In Michigan, speed limits are statutorily defined under the Motor Vehicle Code. The blue book's behind me. Under this law, the speed limit was 55 miles per hour on the stretch of road where Owen was pulled over because there were no signs saying otherwise. And the quote from the Court of Appeal says, "We conclude that the deputy did not have an objectively reasonable belief that probable cause existed to stop the defendant because the totality of the circumstances established that he made an unreasonable mistake of law based on an unsupported hunch that the speed limit was 25 miles per hour. And all evidence acquired in the traffic stop then, including the breathalyzer results and a weapon, which apparently is in there somewhere, must be dismissed since the stop itself was unlawful." Owen's defense attorney believes the case might have wider implications about speed limits, and of course there's some debate on that. But a state law updated in 2016 allows local governments to change speed limits if these changes are backed up by a speed study or solid evidence. The change also must be entered into public record and presumably posted on signs. In the case at hand, there's no public record of Saranac creating an enforceable speed limit to overcome the general speed limit of 55 miles per hour on the road in question. Defense attorney said, "This is a huge win for anyone who drives in Michigan. It is surprising how many speed limit signs in the state are currently now unenforceable. It is even more surprising how many people get cited for speeding when they're actually not speeding. And that's a problem. This ruling may finally help the average motorist win their cases." Now, of course, the prosecutor for Ionia County, who now feels like an idiot, had to go on the record and say, well, he doesn't believe the case will have the broader implications because the deputy did not issue a speeding ticket. So here's what happened. Man's driving down a street in Saranac. He's doing over 25, and a cop mistakenly thinks, based on a hunch, that the speed limit is 25. Pulls the man over, comes to the conclusion he may have been drinking, has him blow a breathalyzer, which he loses on, and apparently also finds a weapon in the search, charges him with the drunk driving and the possession of the weapon, but does not charge him with speeding. Okay? And it's unusual because I've almost always seen drunk driving cases where they always charge with the underlying charge, primarily because they want to show what the probable cause was for the initial stop. So the Ionia County prosecutor, Kyle Butler, said, "I understand what the attorney has been trying to frame this case as, but this case is simply not the vehicle to get to this issue. It'd be different if the deputy had actually enforced the speed limit by issuing a speeding ticket, but that's simply not the facts here. I don't think it's going to have the implication he hopes." Well, but he wasn't enforcing a speed limit. He was enforcing a hunch. I understand the prosecutor doesn't have to hire the cops, so it's not his fault. But, you know, that's what happens when there's a bad case that goes up on appeal and you're forced to argue the side that's going to lose. Butler said he's disappointed in the court's ruling. The road has a 25-mile-per-hour sign visible to northbound drivers, making it reasonable for the deputy to believe that the traffic going the opposite direction would have had the same speed limit. But he doesn't address the fact that the 25-mile-per-hour speed limit is not even enforceable. It's unenforceable in either direction, with or without the sign. So Butler said, for the Court of Appeals to believe the officer acted unreasonably just really goes against common sense, in my opinion. Well, dude, good thing you don't write the opinions the Court of Appeals does, because you're wrong. And as pointed out, it was an unreasonable mistake of law, and basically the stop was bad. So it's an interesting case because, you know, you think about how this squares with other cases we've had recently, we've talked about on the show here. There's a case, Strife versus Utah. Yanked that out of thin air. Where the police saw a man walking out of what they thought might be a drug house, and they stopped him. And then after they stopped him, they found out he had an outstanding warrant for his arrest. And he had argued that the initial stop was unlawful, and our Supreme Court said, well, even though the initial stop might have been unlawful at the moment it was made, it kind of became justified a few minutes later, and they discovered that he had a warrant out for his arrest. So the initial stop is okay, even though it was wrong, because it double secret gets fixed later, retroactively, and so on. So here, the court is saying, well, the police officer made a mistake, and the prosecutor wants to say, well, the mistake is reasonable, though. So the cop makes a reasonable mistake. I mean, you know, shouldn't, and the Michigan Court of Appeals, I believe, is rightly saying, no, the guy wasn't speeding. And so to say I pulled him over because I thought he was speeding when he wasn't speeding means that if the Court of Appeals didn't do this, a police officer could always say, well, I thought he was doing something. I thought he was speeding. I thought he failed to use his turn signals. I thought, I had a hunch. And you'd have a situation where the police could literally just whatever they wanted to, just say they thought something, had a hunch about something. So I guess if nothing else, we should learn a lesson here and salute the police officer for being honest when he said, well, I had a hunch. The speed limit was 25. I had a hunch. Actually, if I was the police chief in Saranac County, or Saranac, but Saranac is probably a pretty small town. For all we know, that guy could be the police chief. But at this point, you send everyone back for remedial training on everything, okay? Because you're not out here to enforce hunches. You're supposed to be enforcing the law. So again, Michigan court rules in favor of a drunk driver because they say the cop had the wrong speed limit, and you can't make a mistake like that and then use the mistaken belief as the underlying cause to pull somebody over and start the chain of events that leads to searches and seizures and so on. So there you have it, straight out of recent headlines. Thanks for passing it along. Questions or comments? Put them below. Otherwise, talk to you later. Bye-bye.